The history of laws and the chronicle of lawlessness. This is Ruська Pravda, the first collection of laws of Old Rus. It consisted of Yaroslav Truce, Yaroslavich Truce, and two more articles. It is clear from the names that Rus Truce was composed by our princes of Kyiv. For centuries, people lived by these laws on the territory of the modern Ukraine. And this is Sudebnik of Ivan III, which is the first collection of Muscovy laws. It appeared almost 500 years later than the laws of the Kyivan state. And this is Mr. Volodymyr Gusev, who is considered to be the author of the court book. By the way, he was later beheaded, and this was the first practical case of using the court book. Let's recollect what norms our ancestor lived by and how different laws split in the Ukrainian and Russian society in different directions. Even the first written sources tell that from the earliest times the society was ruled by brutal force. However, humankind is gradually realizing the need to implement rules to avoid conflicts and resolve disputes. Kyivan princes are known as the first legislators of our state. At least our first church statutes and codes of secular law are named after them. During their regime, the collection of laws, the Rus Truce, appeared. In terms of its content, it was similar to the laws of the European countries of the early Middle Ages. It systematized customs and established social inequality. For example, the amount of the monetary penalty for murder depended on the social status of the murdered person. The most serious crimes then were considered robbery, setting fences on fire, and horse theft. At the same time, the death penalty was not provided at all. The most severe punishment was flood and plunder. This is when a criminal and his family were expelled from the community and their property was distributed among all its members. For harsh medieval times, the Rus Truce was quite human. Most criminals were punished by fines, which were called viras. Well, it is approximately a there is knee for traffic violations. Those days, laws were formed under influence of Western tradition. However, the Mongol invasion prevented them from going the Western European way, which led to the loss of the political independence of our principalities. That is why no new collections of laws appeared in Rus in the 13th century. In Western Europe, the main initiators of new laws at that time were royal power and cities. And in the first half of the 13th century, the Magdeburg Law appeared, a system of the city self-government. It first appeared in the German city of Magdeburg. The residents of the city freed themselves from the feudal court and began to govern themselves. For this, they invented a lot of new things: the magistrate, the council, the burgomovistria, craft shops, notaries, and many other things that have been still working all over the world. Because of its effectiveness, the Magdeburg Law was willingly taken as a model by numerous cities throughout Europe, not excluding Ukrainian ones as well. Thus, the Galician prince Lev Danilovich granted the Magdeburg right to the city of Przemysl in 1301. Later, Volodymyr Volynski received the Magdeburg Law. During the Lithuanian-Polish era, hundreds of Ukrainian cities, towns, and even villages received the right of self-government based on the various models of the European municipal law. What did it give? First of all, protection of the urban population from the arbitraries of large landowners. Secondly, the conditions for the development of the crafts and trade. And in general, it gave distinct rules of life in cities. The spread of the Magdeburg Law on the territory of Ukraine contributed to the formation of new mental features of the local population, a kind of democracy that contributed to the formation of the foundation of the civil society in Ukraine. The Magdeburg law worked only in certain cities. The rest of the Ukrainian lands belonged to the various feudal lords, princes, magnates, nobility. Therefore, the entry of our territory into the Grand Duchy of Lithuania and the Kingdom of Poland in the 14th century had ambitious consequences for the development of law. On the one hand, the Lithuanian princes solemnly promised not to introduce new things, not to destroy old ones, and thereby continued the legal traditions of Kyivan Rus. They even used the Rus truce at first. Only in 1447, the Lithuanian prince issued a general privilege for the state. And in the middle of 15th century, the criminal law and judiciary of Grand Duchy of Lithuania was reduced to a single law, Kazimierz Sudebnik. Well, no. The Muscovy Principality already existed, but there was really nothing about rights. The Magdeburg law was there only in… it was nowhere. If we and the rest of Europe gradually formed a system of self-government, then the few charters of Muscovy of those times were exclusively about the authority of the authorities. Here, for example, there is a Dvina charter that was issued to the governor of Moscow, Prince Vasil, in order to relinquish the Dvina land from Novgorod. According to the documents, the Dvina boyars received administration independent from Novgorod. In other words, it was an act of interfering in the affairs of another state and supporting local separatism. We find the beginning of treaty only in those Russian lands that didn't feel the influence of Mongols and were oriented towards Europe. For example, such were the agreements of Novgorod with German cities and contractual letters with invited princes. It is not surprising that this level of freedom didn't suit Muscovites. That is why the Novgorod Charter already recorded limitations on the independence of the Novgorod boyars. After all, independent and rich Novgorod became the object of expansion, and the war with Moscow finally destroyed the merchant republic of Novgorod and made it the periphery of Europe. So the Moscow rulers tried to get everything for themselves, which was immediately reflected in their decrees. The fact is that they were politically dependent on the Mongols for too long, and they had a system similar to the Horde model, which was built on the principles of authoritarianism and centralization. The law didn't play a decisive role in Golden Horde, and Muscovites borrowed it forever. So, in the power of prince or a king in the Ukrainian lands in the 16th century was perceived as a necessary tool for the application of law. Then, in Moscow Principality, the Grand Duke, and later the autocrat, was not legally limited by anything. The charters were directives to the royal governments, who as a sign of loyalty to the ruler had to kiss the cross, and that was it. Let's compare the laws that were in effect at about the same time in our lands and in Muscovy. The main codes in Lithuanian and Russian state were 3 statutes of Lithuania. They operated in the territory where the majority of population was people of Rus. In the Muscovite Principality, people were sued alternately according to the Sudebnik of Ivan III, Ivan IV, and the Consul statute. The first, or Old Lithuanian statute, consisted of 243 articles. The second was already with 367. The third statute contained 488 articles. The court book of Ivan III had no numbering of articles at all, while the court book of Ivan the Terrible had 100 of them. It was so lame that the king had to make new decisions all the time and immediately issue new decrees for them. Over time, there were so many that they couldn't figure them out themselves. And then the Muscovites created the Cathedral Constitution. So that you can imagine, physically it was a scroll made of paper sheets, glued together, which was 317 meters long. There were recorded 967 articles, the vast majority of which were devoted to the definition of crimes and punishments. It is interesting that many articles from Lithuanian statutes were stolen to it. The Lithuanian statutes can be called the constitution of feudal state. Just in the first article, the prince promised to judge everyone equally, by right. Instead, the Council Regulation of 1649 became almost the most rigid legislative act of that time. It begins with severe punishments for crimes against the king and the church. What's more, even for presenting a man's bid to the Tsar or the Patriarch during the church liturgy, a violator was promised to be imprisoned for crimes for a term that the Tsar pleases. If холopes were still mentioned in the first Lithuanian statute, then there is no mention of slavery in the third. It was forbidden to turn free people into slaves. We also establish that a free person should not be sent to eternal slavery for any crime. Instead, according to Sudebniks, the term Yuriev's Dень was initially introduced. It is a holiday at the end of autumn, a week before and a week after, which the peasants could still switch to another land. But the council already cancelled this possibility, which led to their final consolidation. That's Grandma and Yuriev Day. If the Magdeburg law on Ukrainian lands provided wide opportunities to city dwellers, the Council of Muscovy, on the contrary, forbade urban subjects to leave the Sloboda, effectively turning them into slaves. As for visa-free, the Lithuanian statutes provided for the right of free travel abroad to princes, ensigns, nobles, and boyars. I am free to leave those lands of ours, the Grand Duchy of Lithuania and theirs, in order to gain the best happiness of my own and to learn the deeds of chivalry to all foreign lands except our enemies. At the same time, Yuri Kryzhanich, a Kyivan in Rus service, wrote in his notes of the mission to Moscow that, and to go abroad without his knowledge, as well as an order, is not allowed, unless in this way through entering into excessive communication with foreigners, no harm was done to the sovereign. Therefore, it would seem that the people were rather born a slave than became one. The words of the crowd are confirmed by the papal legate, Antonio Passivino, in the description of Muscovy. Finally, Yuri Kryzhanich concluded, because of the cannibalistic laws, all European nations anonymously called the Orthodox kingdom tyrannical. It is not surprising that with such views, he stayed in the royal service for only 2 years. Then he was sent to Siberia. The criminal legislation of Muscovy was drafted in such a way that the main purpose of punishment was intimidation, and not only the criminal himself, but also the rest of the subjects. Before the appearance of the judges, viras and prodash were applied to criminals, monetary punishments, and thus replenished the treasury. And during the times of Ivan III and Ivan the Terrible, judges more often applied the death penalty and execution. Both that and the other had to demonstrate to the subjects unlimited power over the soul and body of a person. In the 16th century, it gets even worse. Additional punishments such as cutting off the hand, cutting off the ears, tongue, blinding, and branding appear. The state tried to permanently isolate a criminal from the general mass. The execution was deliberately turned into a show and was usually held in the central market square. Death penalties were different: hanging, beheading, groaning, impalement, etc. And these were not the most brutal times. The wave of increasing punishments was in effect the following centuries long and reached its highest peak during the reign of Peter I. The statutes of the Grand Duchy of Lithuania, of course, also provided the death penalty, but compared to the law not only of Muscovy, but even the ones of other European states, their norms were more human. We see this in prohibition of death penalty for pregnant women, the non-jurisdiction of minors, and the punishment of the nobility for killing a common man. Courts in our lands acted in such a way that a monetary penalty compensated the victim, and the state received the compensation for court cost only if the claim was fully satisfied. Appealing to the court also didn't involve any monetary cost on the part of the parties. It was much more interesting in the regard in those days in Muscovy. Viceroys, voivodes, and elder judges there, all of them were fed by the court, so half of all court fines and fines went in their favor. Therefore, they wanted to have as many court cases as possible. Those days, the court began to act only when the parties applied to it. Therefore, many cases and crimes escaped from the court, because the people didn't see the truth in the court and thought it better to resolve all misunderstandings in their environment amicably. Therefore, the governors invented and dragged cases to their own consideration. There will be a fight on the pier. Those who fought will already make peace, but the voivode finds out about this and demands money from them. They find the dead body of a person who died a useless death. That is an accident death. The governor suspects murder, grabs those who seem guilty to him, keeps them in irons so as not to lose the fine for murder. In order to establish such selfish cases, the governor kept special servants with him, davodchiks, who traveled all over his parish and looked to see if their master's fodder was lost. And the most surprising for our modern understanding was the field, that is, a duel. It looked like this. One side, in support of its claim, said that it kisses the cross and climbs into the field to fight. If the opponents agreed, it was called judging to the field. The parties could go to the duel with any weapon, except the pipe and the bow themselves, or put hired fighters in their place. So in Moscow, according to contemporaries of foreigners, there lived people who made a living out of it. The match took place under the supervision of the Duke. The one who lost the battle was defeated and declared guilty. Foreigners wrote that the field was rarely peaceful. There was always a crowd of spectators who closely followed the fighters and incited them and their guarantors. The guarantors watched closely when, in their opinion, the opponent did something wrong, and then immediately grabbed the ball and ran to the field. At the same time, his guarantors caught up with the opponent, also with sticks. A fight began on both sides, which pleasantly occupied the audience. It is interesting that the field was also allowed between witnesses, whose testimony contradicted each other. Wild people. Well, it goes without saying that the judges of Muscovy, when necessary and not necessary, used cruel torture, because the main evidence for them was the confession of guilt by the criminal himself. It is clear that over the centuries, such cruel laws eventually formed a panic fear of their tsars and of any government in general in Russian people. We will remind that at the same time at the Polish-Lithuanian Commonwealth, the principle of the election of the king and the principle of the supremacy of the elected deities over the king was gradually established. That had an impact on all Ukrainian lands. Feel the difference. And finally, the Lithuanian statute has been in force in Ukraine for 3 centuries. The cathedral constitution was also used in Russia for a very long time, until the appearance of the Code of Laws of Russian Empire. So, if in the Polish-Lithuanian Commonwealth, the idea of the contractual nature of the state and the electability of state bodies were gradually restored in the land of Ukraine, then in Muscovy and the lands occupied by it, the ideas of the divine origin of power, which precisely because of this was not under anyone's control, were promoted. As a result, in subsequent centuries, Russian imperial and then Soviet legislation was formed as such, where there was no presumption of innocence or respect for human dignity and life. And Ivan the Terrible and his oprichniks looked almost like fairy tale characters compared to the bloody Chekists of Lenin's time or Stalin's NKVD. From the end of 18th century until independence, the majority of Ukrainian lands were under the rule of country in which the concept of law and the law didn't correspond to their true meaning. Today, we have every chance to build a legal, civilized state where the law will protect every citizen. The path is difficult, but necessary. However, this is how Ukraine becomes a European, independent, free and developed state. You are Ukrainian. Know your history and share it with your friends.